There's no expectation of privacy because you gave up this location information to Google. And since you gave it to a third party, there's absolutely no enforcement requirement. This is a bunch of smart Google lawyers who had said, well, we want to kind of protect our customers' privacy, but also respond to law enforcement. So we'll create this three-step process. The first step would essentially be a collection of the numbers, the anonymized numbers in this geofence area. And then you could go back to Google for a more narrowed group. And then finally, the third step, you could reveal the de-anonymize, create the name of the person who had owned this phone. And so the case involved whether or not this collection or search by the government of 500 million users was a Fourth Amendment search. It turns on questions of, well, did Chatre have a reasonable expectation of privacy in this information? In front of the Supreme Court, the government took the position, it takes the position right now, that no warrants needed. There's no expectation of privacy because you gave up this location information to Google. And since you gave it to a third party, there's absolutely no enforcement requirement. They don't need a warrant. The Chatre's lawyers said, in fact, the warrant is both overbroad in the sense of what you were actually asking for was a lot of people in this area. It was including a church and the bank and a bunch of other people there. But furthermore, this search into 500 million records is a general search, kind of like the general warrants the founding fathers were worried about when they passed the Fourth Amendment. And so the case went up before the Supreme Court. Oral arguments were just this week, where they were debating whether A, a warrant is required, B, whether the search is like a general warrant search, or C, if they followed the Google warrant system. That's what's teed up right now about whether warrants required, whether this kind of search, this kind of reverse search is just overbroad and unconstitutional, or whether a particularized warrant may well be a good compromise to protect some Fourth Amendment protections, but allow law enforcement to get access to this data.
Yeah, so this case really does tee up a lot of the issues because it gets to the whole, do we even have any Fourth Amendment protection? That's the government's position. Or if we do, what is the nature of that protection?